Okay, today North Dakota Farm Bureau filed a suit in court to challenge North Dakota's anti-corporate farming laws. NDFB has taken this step, and this is an important part of it, in the federal district court to finally settle the matter on behalf of our state's largest industry and economic driver, our farmers. The laws of the state, as they stand, are forcing North Dakota farmers and families to make business decisions that other businesses are not being forced to make. North Dakota Farm Bureau believes our anti-corporate farming laws are discriminatory and unconstitutional. Our existing laws favor some family farms while working against other families and their business models. We have members, family farmers, who will be forced to divest their business simply because of their family farm businesses are entering into second cousin that generation. Our family farm members should not be excluded from the benefits of a corporate structure for estate planning, tax management, and liability issues associated with managing family businesses. While other states around us have vibrant livestock industries, as a result of having access to the tools associated with a corporate business model, why should North Dakotans be forced to operate at a disadvantage? For those of you who say these laws defend our family farms, we would ask them, why do states that do not have statutes like our antiquated, out-of-date law have a higher percentage of small family farms than North Dakota does? A review of statistics, of which we've provided for you, available from the USDA National Ag Statistics Service, shows that the states with the largest percentage of small family farms, now this is largest percentage, are West Virginia, Tennessee, New Hampshire, Alabama, Oklahoma, while the states with the smallest percentage of family farms, of small family farms, include South Dakota, Nebraska, Iowa, and North Dakota. Very telling statistics. Higher percentage of small farms in the states that have not had anti-corporate farming laws such as our own. The smallest percentage of small family farms in the states that have the restrictive laws that we do. At the heart of the issue is a simple question of whether the state of North Dakota should be able to pick winners and losers between business entities based on whether the family business is of any size or any business is a grocery store, a cafe, an equipment dealer, a fertilizer salesman, or other ag service providers, or a farm. Now you may have noticed that that list I included are people that farmers do business with, either on the front end purchasing inputs or on the back end selling our products we produce. Why is it that farmers are left in the middle of the food chain not having the same opportunities the folks we do business with on both sides of us? And it begs the question that we really aren't in the middle of the food chain. We're the pivot point for both sides of those selling the inputs to us and those buying the products on the other side of us. But yet, we're left without those benefits of a corporate structure. Our court system is the only appropriate place to settle this question, without the issue being derailed by emotion or fueled by public relations and advertising firms or misconceptions being put out there about what a corporate structure is in farming. This is a perfect example of why we have a judicial branch of government to settle public questions outside of the realm of emotional, personal biases, legislative expedience, and politics. That concludes our formal comments. I'll take some questions at this time. Do you have anything specific that you... Well, there's, when corporate farming's talked about it, they talk about it as in, a big bad corporate structure, that the Walmarts of the world are going to come in and take us over, the ADMs, the Cargills and Wall Street's going to come in here and buy up farmland and start farming, and and young farmers aren't going to be able to get started, and families aren't going to be able to maintain their farm. And that's just, you know, there's only a handful of states that have some sort of a restriction on corporate farming. 80% of the states do not have a restriction on corporate farming, but yet 97% of the farms in the United States are family owned. So if 80% of the states don't have this so-called protectionary law, how can we possibly have 97% of the farms in the United States family owned? You know, they talk about that a corporate structure will not allow extra capital to come in to farming. Funny thing is, I've talked with several bankers that both do agriculture loans and commercial loans. And I said, when your folks come in for a commercial loan and they're changing their business structure from a sole proprietorship to a corporation, why are they doing that? Well, to bring in diversified money, to bring in capital. I go, oh, so a corporate structure allows you to bring in capital? Well, yeah. So that's another one that's being talked about out there, that it's not going to make capital available, which is totally false. By utilizing a corporate structure and being able to have investors, you know, your neighbor, maybe your buddy from high school that is successful and lives in town but would like to have a farming interest again. Maybe he's got relatives that do but has no way or doesn't want to have the day-to-day hands-on, but respects the ability that a farmer out there does and that knowledge he has, and would like to invest his money with that kind of a person. So it will infuse capital into the system. That's just a couple examples of some of those myths that are being portrayed out there. Yes, we are a very direct southern neighbor here, South Dakota, along with Nebraska. In the early 2000s, had similar laws that were challenged, and they are in the same circuit court as we are. If it gets to that point, the 8th Circuit upheld their challenges of being unconstitutional, and so we're cautiously optimistic that we'll be successful with this. We're simply asking the question based on some of that activity that has happened where states have been successful, and to get an answer and end the infighting, so to speak, and the political fighting that's been going on for several decades over this law. Yes, the end goal is to get that determination and then have the law, the parts that the judge deems unconstitutional, removed. There may be, you know, the need to restructure that law because it is a pretty extensive law with some different exceptions in there now, you know, that didn't exist in the very beginning in the 30s when the law was put in. So there's going to have to be some things reworked and redone, you know, to make century codes come into line, probably through the legislative process to strike all that stuff out. Because my understanding of it is the judge will give his order and say, you need to remove these laws. Therefore, legislature will have to take and remove those laws off a century code. Yes, you know, we've been asked quite extensively where we were at during the legislative process when 2351 was passed in 2015 legislative session. We were neutral. We didn't come in strong support. We didn't come in opposition. We had asked for a general exemption for all of production agriculture from the sponsors of that bill. Had a nice sit down with them. They weren't able to go that direction, and so we told them that we weren't going to publicly criticize and be opposed to it, but we weren't going to publicly come in and offer testimony in favor of that. And this is the reason here today that we explained to you why we've been fairly quiet and silent on the upcoming vote on June 14th. Yeah, you know, it's a court process. It's when you get on the docket, and you know, sometime between 12 and 18 months, give or take, depends on how busy the court docket is and the processes that go with that. But you know, we're probably not looking for anything much before 18 months for knowledge of where this will be. It could happen sooner, or it could take a little longer even. There's a possibility. We've, had our discussions with some groups, and it's it takes some time for them to work through their process of, vetting their options and what they want. We've had a lot of people express their support, glad that we're doing this, and it's one of those things that it's hard to put your name on the paper, so to speak. Little bit of fear, maybe some community retribution in a community that you live in when you take something on like this. It's been a very emotional subject, and it's just time to get beyond that emotion and get to the question at heart. And that's what we want to do. We just want to ask the question, get the answer of whether it is discriminatory and unconstitutional or not. And that there's only one place to go to do that, and that's in the federal court.